Hey everybody, welcome to Lawyer Live with Matt the Lawyer. I am Matt Johnston, also known as Matt the Lawyer. Today I want to be talking a little bit about contracts, a little bit about the contract drafting process and kind of imaginary work that has to go into it. I know this seems a little odd to think, but there is a certain amount of imagination that has to go into preparing a contract. See, in order to understand that, you have to, like it's any other piece of writing, you have to understand who your audience is. You have to have done a little bit of an audience analysis as to what's going on. So let's step back and think about writing in general. Writing is one of the many forms of communication that we have, and some forms of communication are very immediate. Face-to-face communication or video conferencing communication. You can see a person's face, you can see their reaction, you can see how they are maybe following or not following what you are saying. So if you've confused somebody, it will show in their face. It will show in their body language. You might not understand what it is or where it is you lost that person, but at least you know they are not following you anymore. When you have email communications, or let me step back, let's say you have phone communications, you get some of the same cues, you get some verbal cues. People's tone of voice might be distracted, or they might not be following you, and at least you know a little bit more than, say, in the written word. Now, there's some immediacy in email to a certain extent, and certainly in things like text or Facebook Messenger or other types of instant messenger systems. You can maybe see what's happening when they're saying something or when they're not following you. But then you have what I call stale mail or document communication, which is what happens with contracts. There is a lack of immediacy. You may write a document and it may be days or weeks before you get any sort of feedback, and that feedback may be lacking in an understanding. So in order to have a successful written communication, you have to imagine what the other party is thinking. You have to sort of guide them along, and it means your language has to be a little bit different than it would be if we were sitting face to face with each other. So in a contract drafting standpoint, it's even more complicated because the person who is writing the contract, a lawyer, is doing so for a client, their client. That client is then going to in turn take that document and give it to a third party. The lawyer has to understand not only what their client wants, but also what the customer wants, what that third party wants. And that's a very difficult imaginative process. And it's one that, quite frankly, is quite a burden on a lawyer. So this is where a client, the lawyer's client, can step back and say, wait a minute, this is what my customers are going to be wanting. This is what they are concerned about. This is how we need to address those concerns. And then a lawyer can take that information and then hopefully draft a contract that works for them. So what kind of information is helpful for a lawyer to have when they're going to be drafting a contract for their client that the client is in turn going to give to another party? The first and most important is, who is this person? Who is the client? All right, simple things like a name, an address, those sorts of things. That's basic demographic information. But what else about it? Does this customer routinely hire these kinds of services or buy these kinds of goods? If they do, there's a certain level of knowledge that can be assumed. If they don't, you have to treat your language a little bit differently. You may not use as many words of jargon. You may not use as many acronyms or abbreviations. You may have to spell out the conduct of the transaction a little bit more detailed steps. Is this person educated? And I don't mean, are they, a PhD holder? Are they reasonably well educated? High school, college, somewhere in that zone. Most consumers are, a lot of business owners are. Are they going to have access to their own counsel? Is it likely that they're going to retain a lawyer for this transaction? I think this is one of those facets that a lot of people forget, is there's a lot of business that takes place that the purchaser, that is the third party in our scenario between the lawyer and the client and the customer, that customer probably is not going to retain a lawyer to review a contract every single time, and certainly not for what they would probably consider day-to-day activities. So is this a type of relationship? Is this a type of transaction that's going to require the advice of an attorney if you're the buyer? If it's not, then the attorney should take steps to make sure that the language that they use is one that is understandable to the average educated person. So you might ask your lawyer to avoid long sentences. You might ask your lawyer to avoid lots of run-on sentences. Maybe when you're dealing with the actual specifics of the transaction, you're talking about bullet point lists or literally a numbered list. Number 1's going to happen, number 2's going to happen, number 3's going to happen. These kinds of factors have an impact on what the contract is going to look like on the back end once the lawyer is done drafting. But the lawyer needs that help from the client. I need that help from my clients. I need to understand who the customer is going to be, because I have to imagine not just what my client wants, but what my client's customers want. That's audience analysis. And audience analysis is like any other piece of writing. Just because it's a contract doesn't mean you should ignore the audience analysis. It's funny when you think about it. If you sent a business letter to a customer, you would have to think about who that business customer is. Think of your contract as just another communication. It's not different. Well, it is different, but it's not so different that it becomes special, that it becomes something unique. It is a written communication. You should address it like a written communication, and you should manage your audience's expectations. In the meantime, there's going to be more of these videos where I'm going to be talking about this contract process where businesses can learn to love their legal. They learn to take control of their legal, and I hope you'll tune in for future episodes. In the meantime, this is Matt the Lawyer signing off. Go out and watch some live soccer. I'll talk to everybody later. Bye-bye.